give a short overview of 4 topics which are although connected but still are relatively different. The first is the official title of my presentation, How Media Freedom is Protected at the European Level. The second is still the European level, so how the Court of Strasbourg can enforce its judgments, so how the judgments of the European Court of Human Rights affect European jurisdiction in the field of media freedom and the deficiencies of that, very shortly, because I think the panel discussion will after my presentation will also touch upon this issue. And directly concluding from the first 2 topics, I will address the problem, which is, although not new, but probably becoming more and more topical, the systemic infringements of media freedom, where individual complaints are just useless to deal with. And last but not least, I will also address very briefly the question of platform providers, which was extensively discussed in the morning presentations, and where I also have a different, or I offer a different perspective from the perspective of the user's freedom of expression. So let's see the European Union rules relating to the media. As you all know, the European Union competences are governed to a big part by the principle of subsidiarity, and this makes secondary legislation very scattered. So there is no general foundation, basic foundation of these legal fields of regulation. Certain parts of the media industry and of the operation of media are covered by European legislation, but far from all of them. So it's not like a national code for a certain field of law to regulate. And what concerns the primary legislation, well, there is primary legislation where freedom of expression or freedom of the media and pluralism are declared. But even there, we can observe certain deficiencies in their operation or functional operation at least. I also listed here the Constitution, the European Constitution, as the first European general document to declare freedom of expression and pluralism, but as we all know, its legitimacy was challenged and it was rejected in the popular vote, so we can't count on that. Then the European Charter of the Fundamental Rights, which already existed before, but it was made compulsory by the Treaty of Lisbon. Its Article 11 declares the respect for media, for freedom of expression, freedom of the media, and pluralism. But the Charter only has a limited effect because it respects the sovereignty of member states to a great extent, so it is applicable only in the field of European law. More specifically, it obliges only European institutions and member states as far as they apply European law. And as we saw, media is only partially covered by European law. So there are big loopholes of the European law applying to media where it's national legislation which deals with European law, and there the Charter doesn't apply. Now, the Lisbon Treaty's Article 2 also has a declaration of certain human rights. But first of all, it's a declaration of values. So they are called values. They are not even called rights. They are not enforceable rights. They are and in the second slide are listed, I cited Article 2. It says that the Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. These values are common to the member states. So it's more like a statement of fact rather than the formulation of any kind of expectation, far from being an obligation. And it is also a lex imperfecta because there's no sanction attached to its non-respecting or non-compliance. Although, and here let's have a closer look of Article 7, because Article 7 was introduced to deal with issues where the member states fail to respect human rights and the values of the rule of law and democracy. It was introduced back in the 90s, if I'm correct, and then a first section was inserted to precede the second section, the threshold of which was considered very high. But I have to tell that even the first section's threshold is still very high. So what does it say? A reasoned proposal by 1/3 of the member states or the European Parliament or the European Commission can initiate a procedure with the consent of the European Parliament where the Council will decide on this proposal with a 4/5 majority and determine a clear risk of a serious breach by a member state of the values referred to in Article 2. Now, not to provoke the formulation like breaching values, what it means in a grammatic, what kind of grammatic structure it is, because you can breach rights, but you can't breach values, in my view. So while the whole outset of the expectations is very vague, the price, the stake that Article 7 uses as a threat is very high, losing membership rights or suspension of membership rights, because that's the end of the procedure. Although the Section 1 determining a clear risk of a serious breach does not really entail any kind of sanction. It would be a political declaration, and still it has never been used. If we ask the question whether it could have been used in respect of Hungary or Poland, what is the audience's answer? I wonder if you think it could have been used. I think it could have been used, yes, technically, legally, but for political considerations, it was not used. And it's a complicated issue, and I don't really want to deal with that at this moment. Nevertheless, to sum up the EU competences regarding the freedom of expression, I identified 3 categories of deficiency regarding the primary legislation's functional operation. The first is legitimacy regarding the Constitution. Its legitimacy was challenged and it got struck down. Its binding effect, which affects the Charter, because its binding effect is very limited. It basically applies only to European law. And the enforcement, which applies to the treaty, whose articles enforcement is problematic. And basically the reasons for this is respecting member states' sovereignty, first of all, and the second reason is the low level of the European Union's political unification and the big differences between the countries at the cultural level and the way they relate to certain fundamental rights and freedoms. And I can also add one observation or thought that the fundamental rights, when the EU was established, were taken for granted by the founding members of the EU and also perhaps by the EU 15. But after the Eastern accession, and perhaps it was not by coincidence that the European Constitution was planned to be passed before the Eastern accession. So anyway, the historical changes defy this assumption that we don't have to put down compulsory fundamental rights obligations because they are anyway granted by the member states. Let me jump to the second part of the second European level, the human rights organization, the Council of Europe's coverage of freedom of expression. And here, while it would be very interesting to discuss further cases, although I couldn't do it so enjoyably as Professor Cole did, but nevertheless, there are very interesting cases relating to this aspect, but I would like to focus on the effect of all these judgments. First of all, the Council of Europe is an international organization, and members of this organization have an international obligation to abide by the norms of the organization, by the statute of the Council of Europe and the Convention on European Human Rights. And according to the jurisprudence, the obligation binds the states, member states, all organs, so not only the executive power, but also the legislative and the judiciary, so they can't limit it to just one power as they sometimes tried. And it's the duty of the Committee of Ministers to supervise the compliance with the judgments, with the court's judgments. Now, the judgments are supposed to have a threefold effect. First, to put an end on the human rights violation that is concerned in the specific case, perhaps to change the specific court judgment that preceded the application, to provide a reparation in form of an in integrum restitutio, so making the previous situation, or if it's not possible, then to avoid a just satisfaction, a compensation to the applicant. And a third function would be to prevent further violations. So ideally, it should have a formative effect on the national jurisdiction or even legislation to form the national legal practice in the direction that such human rights violations are not repeated. And this is not often not the case. What happens when there is no voluntary compliance by the member state? It happens very frequently. As mentioned, it's the Committee of Ministers which has the duty to supervise compliances. Enforcement should be understood very theoretically, or of course, like in all international relations, there is no real obligatory enforcement made possible by the norms. So what can the Committee of Ministers do? It can pass an interim resolution which primarily notices that there is a non-compliance, and if the matter is urgent, then it may encourage the state to make the necessary steps, and if it's very outstanding, then it can even threaten with applying further measures in the case of non-compliance. Theoretically, there is a very similar possibility to Article 7 of the Lisbon Treaty, because Article 8 of the Statute of the Council of Europe allows the suspension of membership rights in case of a serious violation of Article 3, where Article 3 obliges the member states to comply with the rules, to collaborate with the Council of Europe as undertaken in with their signature. However, of course, this never happened. It has never been applied. It didn't even come close to that, although to the contrary direction it happened, because Greece voluntarily stepped out of the organization, quit its membership in 1969 under the military dictatorship, to re-access 5 years later after the political situation changed. And we can also give a very clear list of the notoriously non-compliant states, which are Italy, Turkey, the Russian Federation, Ukraine, Greece, Romania, Poland, and Hungary, and Bulgaria. And of course, some more states also could be listed. These are regularly shown in the written report of the Committee of Ministers, which you can find in a link. I have added some links in my presentation, so if you have access to the presentation electronically later, then you can use those links. So the Committee of Ministers every year issues a report about the judgments, the summary of the judgments, and the situation of the compliances by the states. And it has also some other political instruments to try and make a pressure on the member states. For example, it can require a written report from the member states on the measures that they adopted on the basis of the court judgments. It can refer to the court to question whether member state has failed to fulfill its obligation to comply or not, and then it's the court which can make a declaration, supposedly with a higher legitimacy, that there has been a violation of Article 46, which is an obligation to comply with the judgment. It can also make a statement establishing a systemic or structural violation of human rights, which will come in the third part of my presentation. And what can the court do? The court can issue pilot judgment, which are supposed to be very similar to establishing systemic violations or infringements. So when there are either repeatedly violations of a certain human right or a certain case is repeated again and again in a certain country, then they issue pilot judgments to address structural problems. Although the first pilot judgment was not really such a systematic infringement, but it affected 80,000 people because the compensation for their property right. So it was a little different, but then later other following pilot judgments really defined structural violations of human rights. They usually define what are the typical rights with which a state has problems and addresses the necessity to make a legal reform in that territory. For example, Hungary has such a problem regarding Article 6, the lengthy court procedures, and Article 3, which is the detention circumstances, the very crowded prisons and other detention facilities. And I cited a few parts of sentences from the report from 2015 that the scale of the outstanding problems is alarming, and that really thousands of cases are there without complying with the judgment, and also many such cases concern structural problems. The report from 2016, so the latest report, defines 3 problems behind non-compliance of the judgments. The first 2 are basically connected to the state's ignorance of what to do. So they don't know what really they should do or how they should address those structural problems. The most alarming is the third one, which is a refusal to comply with the ruling, and which reveals fundamental problems with the value system, fundamental gaps between the value system of that certain state and of the Council of Europe's value system. Well, by the way, this is the case with Hungary in the recent years, where the Prime Minister has declared regularly that it is not approving of the judgments of the European Court of Human Rights. Okay, if we talk about a systemic violation, pluralism of the media is one perfect example for that, because this is something which is very difficult to grasp with legislation. It's a value-laden cultural phenomenon, and especially in the human rights system, it can be very hidden. You can have a total lack of pluralism and never have one individual complaint at the European Court of Human Rights or in any other case. There are 2 known cases of the European Court of Human Rights which specifically deal with pluralism. Of course, pluralism also emerges in several other cases, but these 2 cases, the Lancia versus Austria and the Centro versus Italy, they are specifically are directed or focused around pluralism. Otherwise, of course, from the nature of the matter, individual applications are very rare. So individual violations of Article 10 don't reflect the status of media pluralism. It's simply very difficult to touch this issue. Now, back to the European Union's policy. The European Union has targeted this issue already from the 80s, but with the labor market concentration. And although there was some green papers on this, it never really went through. So it was not examined really in details because of the complexity of the problem and because there was no agreement in how to measure pluralism. There was a lack of agreement even between experts in one country and of course between countries. And last but not least, because the competitiveness of the European media industry was seen as and it still is seen as a priority, and they didn't want to put a pressure on the industry with regulations on limiting market concentration. A couple of years ago, a new approach emerged in the European Union, which is characterized by an analytic approach, or analytic nature, and this resulted in the ongoing long program of the media pluralism monitoring research, which identifies risks to the European media pluralism in the various member states. From a very, very complex scheme, gradually, year by year, it became more and more simple, which made it more usable, so it helped the system's usability. And now we have lots of statistics about the situation of pluralism in the European member states. A year ago, the European Parliament ordered a research paper, of which I was one of the authors, on a comparative analysis of media freedom and pluralism in the EU member states, which had a new approach, because the media pluralism monitoring project was, as I said, gave extensive details about the status of the traditional values of pluralism. And our approach was here to measure the state's participation in the media sector and to analyze how a non-transparent and interconnected network of political and economic power interferes with the independence and the pluralism of the media. So the findings were that in fact, the state's invisible hand is deeply involved in the media market in various forms, and that what you see here on the screen, the first of them is also can also be observed in Western European member states. That is the close relationship between third sector companies, which have then a close relationship between the state and third sector companies and media companies, so like a triangle. And these third sector companies are usually those which participate in public procurement, like energy companies, defense, construction, transport, so companies which traditionally or structurally have very close ties with the state. The second, which is also quite common, especially in the eastern part and central part of Europe and the southern part of Europe, is the intransparent system of state subsidies granted to media companies. And the third one is indirect ownership by proxy owners, which is perhaps the most severe form of this kind of invisible intervention. All these interfere with the freedom of the media, with fair competition, and the cleanliness of public procurement procedures in those affected sectors. So the research that I was part of recommended that, okay, if the European Union doesn't want to interfere with media ownership, with the private sector, to let the industry flourish, fine. They should just make sure that the nation states, that the member states don't interfere either with a tool or with their tools that have a chilling effect on the operation and independence of media companies, and which cause a systemic failure of media freedom in certain countries. Now, how can the European Union address this? We made several recommendations, of which I would just emphasize here those which are connected to the AVMSD reform. One is that the AVMSD in its new text or reformed text should require member states to ensure freedom and pluralism in the audiovisual media market by defining the tools and the final goals that the member states should achieve. So not a detailed regulation, just defining certain goals that the member states should achieve. The AVMSD should provide a searchable database. There is such a database at the moment maintained by a private enterprise, but it's not really deeply showing the owners behind the primary owners. So in our idea, this database should show the owners, the identity of the owners until the ultimate private person, possibly not an offshore company. So direct and indirect owners. And regarding the AVMSD recommendations, I mentioned that it would ensure, it would define the tools and the goals that the member states should achieve, and we listed 5 tools that could be mentioned possibly in such a legislative rule. Like all member states, I'm just mentioning a couple of examples. I'm not going into detail regarding this. For example, adequate rules combating concentration in the market should be put in place. So each member state is required to have their own anti-concentration rules. And the European Union would not define what exactly those rules should be, because that would make it very difficult to deal with, given that the media markets are all very different in size and in terms of GDP and culturally and in terms of languages. So, okay, it should be the member states to regulate it, but couldn't the European Union expect that there is such kind of regulation? Then media literacy, the independence of NRAs, which is hopefully in the final version too, and the declared protection of cultural and social diversity. Fantastic. So the last part of my thoughts is the intermediaries, which also add to the pluralism scene of the European media landscape, especially that nowadays more and more content is accessible via the intermediaries, the platform providers, social network sites, and also posted through these actors. So needless to say that the users, members of the audience, especially in the younger generation, are not only listening or watching the media content, but also publishing their own content. And the intermediaries enable both activities at the same time. The old regulation is the e-commerce article, which we actually don't really know whether it applies to platform providers or not, because it has not been declared by a court judgment. I would like to refer here to 2 cases by the European Court of Human Rights. One is the Delphi versus Estonia, and the other is a case of Hungarian relevance, but very similar to Delphi, Index, which is a journal, and MT, which is an NGO. It's 2 different cases which were joined in the procedure. They both removed the allegedly illegal content from their website upon notice, but they both were fined by the national courts for the period between publication by a user and removal by the portal. So the national courts basically treated both publishers, both service providers, as publishers. And in fact, they were publishers because Delphi is a journal, but the comment in question was not its own publication, but a user comment. Index is also a journal, but the content in question was not its own publication, but a user comment. And the same with MTE, although it's an NGO. And I also would like to add, somewhat arbitrarily, because it was not really mentioned in the court procedure, that in all cases, the comments were of important public interest. So even if they were exaggerated, and in the case of Delphi, it was hate speech or very close to hate speech, they were racial comments, but the basic issue which led to the passionate commenting of the users were of public interest issues which affected like consumer protection in the case of MTE and an important financial issue in the case of Delphi. So the interesting thing is that in the case of Delphi, the European Court of Human Rights said that there was a no violation of Article 10. The Grand Chamber repeated this decision. And in the Hungarian case, it established violation of Article 10, but because of reasons that can't be regarded as reasons of principle or structural reasons. So it's because it was not hate speech, and the reasoning of the Hungarian courts was really very weak. So you can't really deduct a conclusion from the difference between the two judgments. And one important addition, that the European Court of Human Rights did not address the question whether the e-commerce directive applies or not, although in both cases the service providers assumed that they are immune from liability. They refer to the e-commerce directive, assuming that they are service providers, either hosting or providing access. We know that the e-commerce directive does not really define platform providers, so you can't really put them into one category, but by analogy, they both thought that it gives them immunity, and they expediently removed the content upon notice. So I understand that the Audiovisual Media Services Directive's new reform proposal provides for a certain type of regulation of platform providers, even though it obliges them to self-regulate, basically, but still it pulls them under the umbrella of the media service providers. It puts them in the category of service providers, which is very close to being publishers. So rather than intermediaries, it puts them into the shoes of publishers. And regarding this, I just wonder if, of course, I'm sure that there was a long impact assessment procedure, but I just wonder whether these questions are answered at the moment. First question, whether there is a right to disseminate content anonymously through an intermediary. So does the general public, like all of us here, have the right to publish anonymous content through an intermediary on the internet? Because if yes, then the AVMSD should not pull them under regulation, because that would eliminate this right. It would deny the public this right. As soon as the platform providers are made responsible for third-person content, they will immediately put a lot of effort into censoring and editing that kind of content. It will be their content from that moment on, and it means that they will act like a firewall, like a gatekeeper, and not allow user content to flow through them without monitoring and without editing. Second question, in case we say no, it's not allowed anymore, although just one thing to add to this number one, of course, publishing, so disseminating content to the public was not seen as a general human right earlier, I think through the media. So you didn't have the right to appear on television or to publish in a newspaper. But in the last 20 years, it's changed, because through the internet it became possible. And I think by now, people take it for granted, for natural, that they have the right to publish information. And of course, I admit, and we all know, that if the goal is very rational, you have to have a certain limit to control hate speech and illegal and harmful content. And if you are still unsure, look at Brexit and US elections. Do you want more, or let's just regulate platform providers, because that will be better. But if you think of the freedom of expression perspective of the users, then let me give this second thought. Okay, so number 2, in case we accept this and we say, okay, let's just go back to the old rule that they are gatekeepers of public information, that the platform providers should serve as a firewall and filter content and only let's do what is decent and probably legal. If somebody, a user's content is filtered out through that firewall, does the user have the right to turn against the platform provider and go to court? Does the user have a legal remedy against such private censorship and turn to the court? It's not settled yet. But I'm sure that it will emerge as soon as the AVM systems into effect. So maybe it would be a good idea to make a declaration of this kind. Number 3, can we draw the line between consciously facilitating speech, and I will tell you the example, and automatically transmitting speech? Like in the case of Semir Güzel versus Turkey, which was a case at the Strasbourg court. Semir Güzel was a vice president of a Turkish party who didn't prevent at a party meeting that other members of the party speak in Kurdish language, which is a crime in Turkey, to speak at a party meeting in Kurdish language. So Semir Güzel did not prevent someone else to speak Kurdish, and for this reason, for this act, he was convicted by a criminal court. And of course, the Court of Strasbourg said that this was a violation of Article 10, and also added that Semir Güzel did not interfere with someone else's right to freedom of expression consciously, because that was also an act of expression by his side, that he let someone else speak Kurdish. Or he himself did not speak, but his action was a type of expression. But can we say that Delphi or other journalists are also doing such a conscious facilitation, take position when they transmit the speech automatically? Or even YouTube, I know that YouTube earns a lot of money, but when someone uploads a video on YouTube, does YouTube consciously facilitate the communication of that video, and shall we make YouTube responsible for that video in case it shows like a beheading, for example, or some terrible illegal stuff? And of course, there are also other types of platform providers, such as blogs, various social network sites that young people use, Instagram, etc. And whether we can draw the line between them all. And the fourth question also relates to this, that there is now a proliferation of these platform providers, from Instagram to all sorts of little independent sites which allow users to disseminate their content, while investing into a compulsory and constant monitoring system which enables 24/7 monitoring, whether certain content is legal or illegal, would be available, I guess, only for big and financially stable and powerful platform providers, which would make small, independent, or even amateur platform providers illegal if they can't do this sort of monitoring and editing function. So it may be interesting that I'm making a presentation and I'm asking the questions, but if anyone from the audience is ready to give answer to these questions, I will be more than happy to listen. So that was it. Thank you for your attention.
Thank you, Judit.